Good morning or good afternoon to everyone joining us today, depending on which part of the country you're coming from. We'd like to give a very warm welcome to all of our viewers. For those of us who are not familiar with quantum business law, we are a business law firm with an emphasis on tax and litigation, and we practice across Canada. We regularly host educational sessions for professionals and business owners on topics including tax, corporate law, family law, and other topics that are pertinent to entrepreneurs in Canada. This is our first session of the year for 2022, and we wish everyone a Happy New Year, and thank you very much for joining us today. Without further ado, we'd like to introduce our expert panel, and we'll jump right into our presentation. First, I would like to introduce Mahyar Makki. He's a partner and a tax lawyer with us. He is very experienced in tax law, in corporate law, and also in litigation. Among one of his accomplishments, he is heading up a class action lawsuit against the government of Canada for $2.4 billion. We're very happy to have him and his wealth of knowledge with us today. I'd also like to introduce Michael Miller. He is a very experienced corporate and commercial litigator with over 40 years of experience as a partner on Bay Street in Toronto. We're very happy to have Michael with us today. And last but not least, I'd like to introduce Todd Louie, who is a senior partner in the tax side with a wealth of knowledge in tax. He's been a tax practitioner and educator for more than 30 years, and we're very happy to have Todd with us as well. And of course, I'm Jeremy Louie. I'm a partner at Quantum, and I'm very happy to be presenting with my partners here today. With that, I would like to jump into the topic. The topic is, for today's presentation, is asset protection. We're going to be focusing on a few areas of the law, including corporate law, family law, and tax law, and how you can protect your assets, what some of the other implications are, and some recommendations that advisors and business owners can implement. So with that, I'd like to call on Todd to give us a brief introduction into asset protection. Todd, please.
Oh, thank you, Jeremy. I'd like to, say thank you to our whole team for putting this subject together. I think it's long overdue. Often I hear business owners, as well as accountants and lawyers, make comments that I at times find objectionable. And one of the things I hear too often is, oh, we don't have to worry about getting sued. We have insurance. Please set that aside. Oftentimes people can fall into a false sense of security. And those of you who have been involved in litigation to any extent would appreciate the fact that you're not invulnerable. So there's many issues that you can run into dealing with corporate related issues. Well, there's the common law principle of controlling mind and management that can be applied to an entrepreneur's conduct. So rather than falling into this false sense of security, thinking whatever the company does, it has limited liability protection, it won't affect me. Well, please, let's consider a number of different things that can happen. There could be issues involving breaches of contract, which you personally had a hand in. There could be certain efforts to recover damages, product liability, discrimination and harassment in the context of family law, employment law issues. There could be environmental law issues. As an example, a lot of us were surprised a few years back when the Environmental Review Tribunal, in the case of Baker versus the Ministry of Environment, held directors and officers accountable for environmental pollution after a company became insolvent. And this is only the beginning of issues. We could really go on and elaborate on many ways. Let's not forget about marital breakdown, and let's not also dismiss the idea that there may be family members of children within your company, your own children, and they might run into marital problems, and it might be that, you've done some tax planning and your children don't really own the shares of the company directly. They may have a indirect ownership through a trust or some other kind of planning. Well, you might become a target. What I'm saying is you not only have to worry about creditors when you accumulate a lot of wealth, you must worry about predators. So with that said, let's get started.
Thank you very much, Todd. So we can see that this is a very serious topic. And in our experience, we see that business owners in Canada are oftentimes neglecting their asset protection. We see so many wealthy business owners who have not taken the steps necessary to protect their assets. And we'd like to start with laying a good foundation for asset protection before we get into the nitty-gritty on the topic. I'd like to call on Mahyar Makki to talk a little bit about laying a foundation for asset protection in your corporation.
Thank you, Jeremy. Thank you, everyone. I'll take 2 minutes to speak about this subject matter. I think it's a good starting point because, like Jeremy said, laying the foundation and keeping your corporation healthy to begin with is a starting point. I know it's a chore to many of you or many accountants to update minute books, but number one is the law. Under Part 11 of the OBCA, Ontario Business Corporations Act, it sets out the duties. But under 256 of the OBCA, it also gives maximum fines of $25,000. But there's practical reasons of why you want to maintain your minute books. Let's say there's a buyer at the door. Last minute, you're going to have to run to your accountants and lawyers to bring them up to date. It's going to be costly for you. What if you want to get a loan? From a tax perspective, what if you've paid yourself dividends? What if you've given business loans? Well, under a CRA audit, they could come in. If you don't have the proper resolutions passed, they're going to deem your dividends to be income. You're not going to be allowed to deduct your loans. So what is the penalties, interest on top of that? And still, subsequently, you're going to have to update your minute books. So as a good starting point of this discussion is, as a foundation, keep your minute books up to date, keep your costs down yourself, and build on that principle moving forward.
I'll just add to that it's infrequent that we get retained by a client whose minute books are completely up to date. In fact, we see companies that haven't updated their minute books in some cases decades. Oftentimes it's unclear who the shareholders are, or individuals are mistaken about the corporate structure. So this is, I think, Mayor, a very neglected area in general. It's something that you need to look at each year to update, for sure.
Agreed.
Thank you very much. So let's change gears now to talk about limited liability within a corporation. It's fairly well known that there is limited liability, meaning that a corporation, the shareholders of a corporation may not have the same exposure to liabilities as the corporation itself under Canadian law. Now, Todd, can you give us some background to this, please, before we get into the diagrams?
I think that one of the primary, issues that business owners would do well to consider, is if you're moving money, say, from an operating company to a holding company, that may not be the safest thing for you to do for a number of reasons. Oftentimes, business owners suffer under another misconception, and that is that the money that's sitting in the holding company is now safe and doesn't really attract any problems. Well, quite the opposite can be true. From a liability point of view, Section 160 of the Income Tax Act can have the effect of CRA tracing a dividend, following a dividend from the operating company up into the holding company and seizing those funds. So much for that idea. That's one problem. There are other tax-related issues that can come from this, such as the loss of the capital gains exemptions. And sometimes there could be many on the shares of the holding company. Well, a lot of times the advice that our clients have received is that it's okay to do that because the capital gains exemption would apply to the operating company and not the holding company. Well, that is not the case in many instances. In other words, if you haven't done what we call an estate freeze, you've really created a tax problem for yourself insofar as the holding company owns 100% of the common shares of the operating company, and the cash that's sitting in there can be a serious problem. Also, I would be concerned about the Fraudulent Conveyances Act that we'll talk about a bit later, as far as those funds becoming a target from from predators and creditors who might have a claim against an operating company who could potentially follow those funds.
So, Todd, you mentioned fraudulent conveyances. As we can see here in the diagram, what this entrepreneur has done is moved the cash and investments, paid them up to Holdco, presumably through an intercorporate dividend. But what you're telling us is that it doesn't achieve the asset protection that the entrepreneur is looking for. And it also does not solve some tax issues like the capital gains exemption, which you would hope to qualify for. So this is not a good solution. Let's go back to asset protection for a moment. We'd like to talk a little bit more about the limited liability and piercing the corporate veil. I'd like to ask Michael Miller if you can talk a little bit to us about piercing the corporate veil and what entrepreneurs, business owners should be concerned about when it comes to asset protection and their limited liability.
Thanks, Jeremy. Well, it's become increasingly popular for claims made against a corporation to add the director or the only shareholder or the officers of the company to get to their assets beyond what the corporation has. And piercing the corporate veil it's taken a trend now where it's a lot more popular to do just that. And in fact, it causes the corporation, we have a couple in the office now that we're working on, you have to bring a motion, you have to do all sorts of stuff and explain to a court why the individual shareholder, director, officer should not be held liable. And if they're the only person operating the company completely and doing everything they choose to do and disregarding other things, relying on their limited liability, they may lose that. They may lose that. And then the assets of the individual are open for grabs.
Thank you, Michael. Go ahead,
I
Todd.
might just elaborate a little bit on some of the things that cause us concern. Canada has regrettably adopted legislation from the Middle Ages, right? 1600s. I referred to it a moment ago, and maybe we could just talk about it now. I've referred to it as the Fraudulent Conveyances Act, which is known as the Statute of Elizabeth. And this archaic legislation has the effect that if an individual or a corporation is attempting to hinder, to delay, or defraud a creditor, the court can be asked for a special award by a plaintiff that can have the effect of piercing a corporate veil. This is a little bit alarming. So the point is that, we work hard to build up assets our whole lives, and certain things we don't hesitate to do, like buying, say, insurance. But is it enough? Well, arguably not. So when you think about whether or not, we're invincible and whether or not a claim can be made in excess of your liability insurance, or that you can, for other reasons, be held personally responsible, then it's time to consider what other options exist.
Thank you very much, Todd and Michael. So holding assets inside of your corporation, the assets themselves are increasingly less safe from creditors. That's one issue. Let's just come back to the tax issue and other problems caused by having assets in your corporation. Maybe Todd, you can elaborate on that, please.
Yeah. The law is very straightforward when it comes to entitlement to certain kinds of benefits. As an example, small business deduction is available to companies that meet a certain threshold on the first $500,000 of income. And they enjoy this very nice rate of, say, 12.5% of combined federal and provincial taxes. Well, that's great. Well, the same thing applies for other benefits, such as the lifetime capital gains exemption. Well, the legislature did not intend business owners to hoard cash. They intended for cash and non-active assets, investments, they intended them to be used in the company for purposes of running an active business. So if you're hoarding cash, then you could be losing the capital gains exemption. Not only for you, but for your spouse and children and future grandchildren, perhaps. There could be millions of dollars of lost capital gains exemptions that are being caused because you're not purifying a company. So this is an area that frustrates me a little bit because most accountants are aware of this, but I think one of the problems is there's a lack of solutions, known solutions. Fortunately, we do have solutions, and we're going to talk about them today, but some of them are considered by some to be exotic. And for that reason, if we're not very comfortable about a subject, well, sometimes we won't discuss it. And that goes for lawyers, accountants, and business owners alike. So in reality, the solution to having the loss of a capital gains exemption, because you have more than 10% of the assets in your group of companies in non-active assets, such as a bunch of cash sitting in a savings account or your general account is not needed, well, that's a problem. Also, personal use properties are a problem too for other reasons. For that reason, plus CRA can assess you if you happen to keep real estate that you have access to. You can be assessed in one of two ways. One could be the fair market value, the rent of that property. The second could be the potential earning value of that investment could be assessed against you as well in some circumstances. So it's generally a problem to commingle assets together. Active assets should not be commingled with non-active assets. You need to be able to have a way to remove them now and in the future automatically without triggering tax. When you move money from company to company, it has to be the right company, not just the holding company. Maybe it has to be a sister company or some other kind of company.
Thank you, Todd. So holding cash and investments inside of your operating company is bad for a number of reasons that we just covered. What can business owners do if they currently have assets accumulated within their operating company?
Well, that's a loaded question. And I'm going to say, like, there's a multitude of things that can be done. What worries me the most, though, is business owners that are fully exposed in a way that they didn't contemplate, right? And what I'm saying is, sure, there's things you can do to create a benefit from limited liability by holding assets within a corporation. But what about the guy at the top? What about the guy that owns the shares? Well, aren't those a problem? Can those not be a target for multitudes of reasons, even though the shareholder might not even be aware of it? So those of you who are accountants and lawyers in attendance, I think that the responsibility is yours to make it crystal clear to your clients that they have to do more. A shareholder of a company is a target, period. So oftentimes, corporate structures can be reorganized, having the effect of protecting the assets under laws that have been around for nearly 1,000 years. And I'm talking about the law of trusts. Family trusts are a very big part of the work that should be done for any successful company in Canada. And I'm saying that because you don't really own the shares if it's held by a trust. Someone trying to sue you is going to have a harder time. You can control the company from an operational point of view and a director point of view. But as far as the actual ownership, of the shares themselves. It can be held by someone else, and this is a start, but not a finish.
Thank you, Todd. We're going to come back to this later on in the presentation. There are corporate structures that you can implement that provide for asset protection and also provide for the ability to be able to move cash and investments out of an operating company tax-free to another holding vehicle to accomplish that asset protection and the corporate purification that we're talking about. And we'll come back to this later in the presentation. We have to move on. We promised that we would talk about family law, and we're going to brush upon that now. I'd like to call upon Michael Miller, who has some family law considerations for business owners concerned about asset protection. So, Michael, please.
Thanks, Jeremy. So the statistics aren't very accurate, but around 52% of marriages end in divorce in Canada. Around 52%. I think it's really more. But consider that there are people living together who separate and are just not married. And consider people who have separated and just don't file for divorce. So I would think that the statistics are well into the 80%, 70, 80%. So that's a lot of people getting divorced. And so when they do that, there's equalization that takes place between the spouses of people who own shares. So do people who set up a company sometimes ask their spouse to be a shareholder? Yes, they do. And the director, yes, they do. And they do that for many reasons. Some is sort of family considerations. Others do it for tax purposes. But when it comes to separating and divorcing and asset splits, now there's real trouble because you're not dealing with a friendly person. You may not be. It's nice if you're separating and it's all peaceful and sweet, but quite often it's not. So now you have someone who we could call, I called it separating with an enemy. Todd actually likes it better, doing business with an enemy. And either way, it's the same thing. So you now have someone who has shares in a company that you own, or you always thought you owned, and what happens to those shares. So the Family Law Act provides for equalization of net family property. Your shares are the net family property, so that would be looked at. But what happens if the family law doesn't give any teeth to what happens to those shares? The Ontario Business Corporation Act does, as well as the Canada Corporations Act, Business Corporations Act, and it gives lots of ways to control that company that spouses are fighting over. So one of the ways it does is that you can cause a review. You can go to court and say, I want you to review the corporation. I want to know what's going on. I want to invoke the oppression remedy. And the court could order the business owner to provide all sorts of financial information. The court can order that in some cases that information that the operator does not want the world to know or become public is given out. The court can order many things that really upset the operation of the company. It also can order, under the OBCA, it can also order that your shares be bought, your spouse's shares be purchased by you, or they can buy your shares. When the shares are being purchased, they're not given you're not given the benefit of there being a minority discount, because in fact, the court orders that this discount is not permitted when it's being bought pursuant to this court order. So the shares are at risk, ownership is at risk, operation of the business at risk. And keep in mind, if you are a shareholder, operator, owner, director and you have other shareholders beyond your spouse, they may have been very happy being a shareholder with you, but they may not be happy being a shareholder with your spouse. So it causes all sorts of liability problems within that of the corporation as well. So this can be dealt with by a marriage contract before you get married, when you get married, but that requires independent legal advice. The Attribution Act says you have to be fair and reasonable and equitable, and all of this can be taken care of by a proper marriage contract, but that has to be something that both parties have signed, both parties have had independent legal advice. It can't be any duress. I won't marry you unless you do this. That won't work. The father of one of the spouses says, I'm not going to do it, or I'm not going to do ABC. It becomes a major problem. So these things have to be thought out very carefully.
There's something I'll just add to that. And another thing sometimes that I find a little bit objectionable. And I hear accountants and sometimes lawyers giving advice to their clients and saying, well, since the Family Law Act provides for an equitable distribution of net family property, meaning property that's acquired up until the time of marriage, well, we'll just give each spouse 50% and it'll be the same anyway, because she's entitled to 50% no matter what. Well, Michael's just mentioning here that there are certain rights that shareholders have. There's oppression remedies for minority shareholders. There's various different obligations that shareholders have to each other beyond being married. And Michael mentioned that, well, you end up being in business with an enemy. And that's effectively what happens when people, usually, not always, but often, it happens in the event of a marital breakdown. And the problem that you may have is you may not want to be able to run the business in the way that you hoped to run it. What about that equipment you want to buy or expansion of a company? Well, you've got another shareholder who could interfere with your plans. So all I'm saying to you is that when you have clients that are coming to you and saying, who should the shareholders be? Consider that issue, right? That's one thing. Second thing I'd urge you to consider, I guess it's sort of outside of the issue of family law again, but when you're considering who the shareholders of a company should be, and it's, you know, a complicated structure, don't just pop it into the holding company that you put the same prior 3 or 4 companies under, or however many you did that with. It might be the very worst thing to do. You need to consider some of these other issues, both in the context of family law, but also in the context of tax law.
Thank you, Todd and Michael.
I just want to add, Jeremy, if I may, we all know about home ownership. And if you own, what's important is if you owned your home before you got married, your spouse moves in with you, that house is 50-50 from now on. It's no longer 100% the spouse who had it or inherited it. It is now 50-50 for the ownership of the house. No matter you paying all the mortgage, you paying to remodel, you paying to whatever, at the end of the day, that part of the equalization is 50-50, unchanged. I just wanted to.
It's a good point, Michael. Todd and Michael, Mahyar, do we have any examples of issues that we've seen with spouses, family law issues in corporate clients? Do you have any examples that you can share with us?
I'll kick that off, maybe, if that's okay. I would say that we've had clients come in that have said, oh, my wife only owns the shares for tax purposes. Right? Meanwhile, they've separated, they haven't yet divorced. And of course, well, there's a permanence to share ownership. And that's something that you can't just give and take back. Once a person owns shares, that's their property. And we've seen that lack of awareness. Oh, but she doesn't really own anything. Well, no, I'm sorry, but she does. There are certain provisions that can be made when spouses are not yet divorced, but they're living separate and apart, where shares can be gifted from one spouse to another without generating any tax up until the time that they're divorced. The problem with shares being sold or otherwise gifted is they generate tax. It's the same as if you've sold them. We're seeing a tremendous lack of awareness from business owners about those kinds of facts as well. And we see, we have one client recently that passed away and had tens of millions of dollars of assets and was not aware of the fact that when you die, you have to pay capital gains taxes on the shares. And the family got hit broadsided, completely unexpected. This individual died in a testate, meaning he died without a will, and made things very complicated. There was a lot of litigation coming out of that situation with other family members. And just failure to have a will is a problem. Failure to have a shareholders agreement is a big problem. I don't know what the statistics say, but I would hazard a guess that a good number, perhaps more than half of small, mid-sized businesses may not have their house in order when it comes to those kinds of issues. And I'm shocked to see the amount of wealthy people that don't have wills that are up to date. If you don't have up-to-date wills, well, you could have a lot of problems later in the family that's unnecessary. We see a lot of family problems. We see a guy walking away from a company. They start a company. 30 years ago, the two shareholders had an argument. One guy walks away, never comes back again. They never speak again. Well, the guy still owns half the company, but he walked away 30 years ago. Company today is worth tens of millions of dollars, and a guy who did nothing to help build has legal entitlement to that company. That goes back to Mayor's point about reviewing minute books. That's how we discovered it. We reviewed the minute books. We said, wait a minute, who's this fellow? Oh, don't worry about him. He's out of the picture, hasn't been around in years. Well, you must worry about him because he can come back and take half your company now because you didn't keep your minute books up to date. You didn't get proper advice. And there's a minefield that you're navigating that you're doing so blindfolded if you're not updating your minute books every single year.
Michael.
Another problem, Jeremy, can be when you put your children on as shareholders and officers, directors, and they grow up healthy and happy and get married, and their marriage doesn't work. Often, it's not unusual, I'll say, that other spouse says, well, I worked for my father-in-law, and he always promised I'd have part of the company, and then I'm getting divorced and I'm out on the cold. So those type of lawsuits are quite common when in divorces. So that has to be taken into account. The other type of thing that goes on quite often is when parents want to help the son or daughter who's married buy a house. And they're going to, whether it's a loan or a gift, is never really certain. And they don't register anything. And then when that couple separates and the house is divided, they're out their money. She gets half of the money you put into the house, or he does. And so that's also a worry. There are ways to help your children and not come across that risk as well.
Yeah, I just might add to what Michael's saying, and we like to not just offer solutions, but, go a little further, really understand the uniqueness of each situation. But I'll generalize once again. A few minutes ago, I mentioned that a trust can be effective to put your shares of your company and other assets out of the reach of creditors. Well, Michael's now talking about introducing children or the next generation as shareholders of your company, and the fact that that might be a big problem in the context of matrimonial law. Now, one good solution, again, is that issue of the trust, the same kind of trust. And a trust is, I mentioned previously, has over 900 years of history in common law. It's very well established, is rooted in antiquity. It goes back to the days of the Crusades, where they were not sure if they were coming back from fighting the holy wars. Trusts are an arrangement between you and your family members primarily. And essentially, in addition to asset protection, it can provide for a good way to transfer the assets to the next generation. And by the way, you can do it tax-free, which is a fascinating tool. We call it an estate freeze in Canada. In the United States, we can't do estate freezes. I think this is one of the most misunderstood and underutilized tools in the tax planning arsenal.
Thank you very much, Todd. Let's change gears now. We'd like to talk more about trusts. We'd like to talk about some specific ways we can utilize trusts to achieve our goals. Mahyar, do you have anything to add on trusts before we move on to talking about some jurisdictional issues?
Sure. I'll just step back for a second. And generally, I know everyone in the audience knows about trust, but just touch on what Todd said, maybe repeat some points. Generally, what a trust is, it's an entity where you're holding assets for the benefit of the beneficiaries. The trustees can invest, enter into third-party agreements, contracts for the benefit of the beneficiaries. Once assets are transferred into a trust, it no longer belongs to a transfer, but the beneficiaries. What we know about trust, it's a great tax planning tool. It helps mitigate against tax liabilities upon death. Under Section 70 sub 5, when you pass away and you don't have a trust or you don't have anything in place, your family members are left holding the bag, a big bag sometimes we see, because all your assets are deemed disposed of. We know that you could multiply your lifetime capital gains using a trust. It's a great tool. But as Todd mentioned, what surprisingly a lot of professionals don't talk about is how powerful of a tool it is for asset protection, is how you could protect your company. You built this great company over the years. You have hopefully a lot of assets and millions of dollars. One lawsuit attaching your properties and shares of your corporation can wipe you out. And as Todd mentioned, it goes back to centuries, trust law. During the medieval times when they would go out to fight the wars, that's why in our Western jurisprudence, it's very protected. Courts are reluctant to break a trust. Minor times under OBCA, oppression remedy, or mainly under family law issues when there's a equalization in net family properties. For instance, Court of Appeal 2 decisions in 2018 went opposite ways in Spencer versus Riesberry and Tremblay versus Tremblay. One of those cases, the court broke a trust because the husband was exerting control over the trust. But that again is only under that setting and is very rare. That's why trusts are utilized to help mitigate against lawsuits, to help in terms of bankruptcy. You don't want, if a bankruptcy does occur, do you want the trustee to take control over all your assets? If done properly, you can have clauses in there and turn your voting shares to super voting shares. Also, Todd touched about, sometimes we have children, and unfortunately, sometimes our children marry bad. Do you want an internal creditor to come attach assets to the lifelong business you've built over the years? So these are some of the things I think, aside from amazing tax planning, reduction of taxes, and everything that we know about trust, what many don't talk about is the great asset protection that trusts provide.
Thank you, Mahyar and Todd. So we've heard that trusts can provide some tax benefits when used with estate freezes. We've heard that they can give us flexibility in selecting our beneficiaries and what to do with our assets after we die and so on. Let's hone in on this asset protection issue. We've heard that about the issues with family law and divorce and net family property. We've heard about the Fraudulent Conveyances Act and moving assets out of your corporation. You have to consider future creditors. So with that type of legislation in Canada, it seems to almost favor creditors. So I'd like to ask Todd, how can we build in more asset protection to the family trust to protect our assets?
Yeah, so number of ways. First of all, rather than focusing too much on the instrument or the tool, let's talk about really the solutions. And if it's your goal to protect your assets from creditors, whether it's an external creditor like CRA or the bank or a client or somebody that you run into a dispute with, or it's an internal creditor such as a family member who becomes unhappy. Maybe it's a son-in-law or daughter-in-law who decides to sue mother-in-law and father-in-law because the spouse doesn't have any money. But he or she worked, 7 days a week, 10 hours a day in the business. They were promised the moon and the stars. And now the target becomes you. Well, it's not funny because it happens, right? So how can you protect that? Well, you can do so in certain ways that can have the result of protecting the growth moving forward. That means the sooner that you act to reorganize your corporations in assets in a way that the future growth of the assets and corporations are held by a trust. What you're doing is you're separating out the assets that exist at today's value from the future value that will grow from today forward. And you're rather limited in what you can do to protect some of these assets that you hold personally. Now, a number of things need to be considered. So first of all, I would like to talk about the number of business owners that have done estate freezes in the past. Now, for those of you that are unclear of the precise meaning of an estate freeze, it essentially means that you're freezing, you're limiting, or otherwise capping the value of your shares that you own in a company at today's value, having the effect of the future value going to, say, a trust. Well, for individuals that have done that, they often set up a trust so that a spouse is a beneficiary of the trust. Well, I think that's a serious problem. Maybe Mayor could elaborate on one of the issues with having a spouse as a beneficiary in some cases.
Thank you, Todd. Just a quick point on it is, although the CRA hasn't utilized Section 74.4 attribution rules, we've taken an internal deep dive on this subject with our counsel, Todd, on this issue. And we're seeing that if originally a spouse is not a shareholder of an operating company and we put her as a beneficiary, there might be some attribution rule issues with that. So each file is very unique. Each file we have to take a really deep on. It's not simply as, hey, let's set up a trust. We have your spouse, let's multiply the capital gains. It takes a lot deeper dive, and it starts with the minute books. It starts with who are the shareholders and how we can transfer the assets successfully without dealing with these minefields like 74.4.
I just noticed there's a question about what are the attribution rules? Well, essentially, in this particular case, Mayor is mentioning the spousal attribution rules in 74.4 of the Income Tax Act. And essentially what it means is that a benefit is essentially attributed back to another person, having the effect of the other person being taxed. Well, we're concerned about the wording in 74.4 because it's so broad that we are very concerned, and we're not alone on this. We're hearing this from other of our colleagues across Canada and elsewhere, that the concern about the wording is that CRA can apply it so that if you did an estate freeze a few years ago, say, and say that you froze the shares at $5 million. Well, if the spouse is a beneficiary, there can be a 1% tax of $500,000 per year to the freezor if you're not careful. So there's certain conditions. One exclusion to this is whether or not the underlying company meets the definition of a small business corporation. One of the definitions that we talked about a few minutes ago was whether or not the shares of a corporation are eligible for the capital gains exemption in light of non-essential, non-active assets like cash, bonds, stocks, marketable securities, whatever, sitting in a holding company, say, that might not even be in the active business that causes the loss of the capital gains exemption. Well, the same problem by extension can mean that you now have to worry about these spousal attribution rules. If you can stay on side for that, that's important. Another thing by extension, I'll mention that we see a lot of companies that have done estate freezes and set up family trusts, thinking, well, everything's great. It's not. It has to be maintained every year. So if you did an estate freeze 10 years ago and you're feeling like you have nothing more to worry about, that ship already sailed. Well, it didn't go very far. In fact, it better come back to port because you have to do some repairs to it. Otherwise, it'll sink, right? So what I'm getting at here is that we see situations where there's millions of dollars of non-active assets that is either present when people do estate freezes that shouldn't be because it takes away the benefits that you're trying to achieve if you're multiplying capital gains exemptions, or you can have a negative consequence later because you might have 10 beneficiaries in the trust, 10 potential capital gains exemptions, close to 10 million of tax-free proceeds at a liquidity event, but none of it is available to you because you didn't purify the company. That means you didn't remove these assets in a way that doesn't create any tax, which can be done. Again, the solution to most is elusive, but there are solutions. Things that are called butterfly strategies, butterfly transactions, and other ways of moving money to a way that they're not connected to the active business. You do get the asset protection, you do get the tax benefits, but it does take a very close look. And that's what we encourage you to do, to have a very close look at things that you might have just dealt with and moved on, right? So time to go back and look at that again.
So Todd, can I just jump in 1 second? Somebody was asking generally attribution, why the effects of it in our chat. Just another 1 minute, why that's an issue. Overall, the Income Tax Act and the CRA does not like income splitting. So they don't want a founder of a corporation to reduce their taxes by transferring assets to their spouse. That's why they'll use the attribution rules 74.4 to attack it. They want to reduce income splitting. I mean, we could go back to the history of 1972 with the Carter Commission and Kenneth Carter, why we use the individual as a unit for taxation versus the family, which caused all this problem. But we are where we are today. And part of the reason of 74.4 overall, just to answer your question quickly, is they don't want spouses to reduce their income by splitting their income or assets.
I'm afraid we have to move on in just a minute, but I just to recap what we're talking about, it's estate freezes and family trusts are great tools that we can use to accomplish our goals, but there are many pitfalls. Attribution rules, the QSBC shares for the capital gains exemption. This is why it's important that you seek good advice from a qualified professional to set up these types of structures. It's not as simple as going to your corner street law firm and getting some shares issued and writing a trust deed. There's a lot more that goes into it, a lot of tax considerations that have to be worked into a plan like this. So it's imperative that you seek good advice. Yes, please.
Just before I go on, I'm sorry for interrupting. I just wondered if Todd, through a conversation that we had last week, I learned that you can have more than one estate freeze. Can you talk about that for a moment?
Yeah, I mean, if you have one of those, entrepreneurs who did an estate freeze, the other issue is, what about the possibility of refreezing again? Because there's a number of reasons that might be possible. One reason is you might have had a reduction in the share value of your company. And for that reason, it can allow you to refreeze. Another issue is every 21 years, a trust has to be go through what's called a deemed disposition rule, whereas the assets have been treated as if they've been disposed of every 21 years. So if you're 18 or 19 years into the period, if you don't do anything, you're going to generate a mammoth tax bill. Another issue that I can see a lot of happening, and this is coming to mind, it's a little bit unrelated, but individuals that fail to report income when they die, I mentioned that happens a lot. Then people leaving Canada. When you leave Canada, you're no longer a taxpayer from a Canadian perspective. You're not a resident anymore of Canada. Well, you die to Canada, in effect, and you have to pay taxes like you died, right? So then, of course, if your trust is getting up there in years, don't wait until the 21st year before you remedy that period under current tax law. There are ways that you can extend that for another 21 years. What's critical to understand, if you do nothing, then the trust has deemed to have disposed of those assets in the 21st year, and you're going to trigger a lot of tax without even knowing it. So it's one of those things that I think you need to have reviewed, maintained, and there's a lot of ongoing work and attention that your structure would need for those reasons too.
Before we put the corporate structure, the sample corporate structure up on the screen, I'd like to ask Todd to comment on what are some of the benefits of using a foreign trust jurisdiction for an entrepreneur looking for asset protection. Why would you want to leave Canada?
Yeah, I mean, first of all, I wouldn't say you're going to leave Canada. I'd say like there's a lot of very successful, wealthy Canadian families that choose to use trusts outside of Canada. Now, some do it for the wrong reason, and I wish they wouldn't. In other words, some do it because they're trying to take advantage of lower rates outside of Canada. And of course, there's legislation in the Income Tax Act that are called the deeming rules, and Section 94, and has the effect of deeming a trust outside of Canada to be a Canadian trust for tax purposes when an individual or family is setting up a trust for the wrong reason. So let's just take a step back and say, well, why would someone want to consider in a non-aggressive fashion setting up a trust in another jurisdiction? Well, one reason is because of the Statute of Elizabeth that I mentioned previously, that has the effect to potentially break a trust. A court could break a trust, although it's not common. They can certainly do pierce corporate veils, and that can happen. And that means that this, if the court finds that you have attempted to hinder, delay, or defraud a creditor, well, I'm a little bit more worried about it because of a famous case. It's actually a Supreme Court of Canada decision called Ottawa Wine Vaults versus Mahyar. And in this particular case, well, the Supreme Court of Canada rendered a decision that states that not only should we be looking at our existing creditors that we have now, but also our future creditors. And that case has been applied several times over the last few years in the Federal Court of Appeal, as well as in lower courts. And it's become what I believe to be good law. And therefore, you don't know who your future creditors will be. And therefore, Canada is not the greatest place in the world to have a trust. There are jurisdictions like New Zealand, Cayman, Barbados, St. Lucia, that are Commonwealth jurisdictions that have similar laws that we have and less stringent laws when it comes to favoring creditors. Canada has regrettably become a creditor-friendly country. And that's why record numbers of wealthy Canadians are setting up trusts outside of Canada in places like those jurisdictions that I just mentioned. Now, in some cases, there can be a natural consequence that results in a lower tax rate when we set up trusts outside of Canada. Essentially, there are instances where you can achieve all of your goals of protecting your assets. And because of the fact that you have a corporation, say, that earns capital gains, or I'm talking about non-active income now, like investments and so on, or earns, say regular interest income or other kinds of investment income. Well, in the province of Ontario, as an example, I know that some of you are here from BC and Alberta as well, and welcome to you. And the rates vary slightly, but in Ontario, the tax rate for capital gains is 25% inside of a corporation on account of the federal refundable tax. Well, if you are able to create the protection for your company and for your family and your estate in the way that you should be doing, and it results in a situation that you have shares that are controlled by a trust, say in Barbados, without taking advantage of the low tax rates there. The natural consequence is the capital gains rate would go down from 25% down to 13.25%. And if you have passive investment income, rental income, whatever, well, that would go down from 50.17% down to 26.5%. So there's lots and lots of benefits to asset protection that occur because you're prudent and you arrange things properly.
And one thing that's not proper is a trust in Delaware, for example. There are other locations as well. Do you want to address that, Todd?
Well, I'm not going to say not proper. What I am a little concerned with, and have been for a long time, are continuances where people will continue a Canadian corporation into a place like Delaware, like Michael said, right? Or perhaps British Virgin Islands. And of course, these are artificial. These are tax avoidance, pure, simple tax avoidance. In order for your planning not to be tax avoidance, you need to have a bona fide purpose for what you're doing other than saving taxes. You must not be doing something that results in a misuse or abuse of the legislation. And essentially, there has to be a tax benefit. That criteria was established by Canada Trust Co. versus Her Majesty the Queen a number of years ago in what we call GAR, the General Anti-Avoidance Rules. So in effect, the acid test or the sniff test, or whatever kind of test you want to call it, means that you must be considering the effects of your planning. And can that planning be done for purposes other than tax avoidance? And is it a misuse of the legislation or not? Well, every situation is different. You need expert advice.
We're almost out of time. I'd like to spend just the last couple of minutes talking about a sample structure that can solve a lot of the problems that we've brought up today, such as the question of asset protection, how we're utilizing a trust and estate freeze, and how we're purifying the corporation from assets. This structure can do all of those things. Todd, can you just take a minute to give us a brief overview of how this structure works?
Yeah, so this is a classic estate freeze. You have an operating company on the left, and on the right-hand side of the screen, you have an investment company that has the non-active assets I was talking about previously. Well, we often would set up a trust that would protect the future growth of that company and allow for the distribution of assets within the first 21 years to be done tax-free to family members, children, whomever, even other corporations. And essentially on the left, the OpCo, we have an entrepreneur that maintains voting control of that company. Then we have a foreign trustee, a trust company, which is, say an insured and bonded trust company that perhaps handles billions of dollars of assets for wealthy families all around the world. Well, we'd have that trust set up for purposes of really giving the kind of protection that you need. And then, of course, on the right-hand side, this investment company also benefits from that protection, but we take it further. What we do is we give the voting control of those shares to the foreign trust, and we keep everything in Canada. In other words, the investment company is, say, a Canadian corporation, as is the operating company, but the controlling shares of the company on the right, although it's a Canadian company, the shares are controlled by a foreign trust, having the effect of a lot of benefits. Now, I mentioned a natural consequence. Well, quite clearly, when you have passive income or capital gains and regular income, so on, inside of this kind of a company, you are taxed at this higher rate. Now, because of the fact that the company is a non-Canadian controlled private corporation, now we've already elaborated extensively on the purpose, because I did say that you need a bona fide purpose other than tax avoidance. Tax avoidance here takes place. This is not a tax play. This is not aggressive. This is very good intergenerational asset transfer of wealth. It's asset protection. It's tax efficiency. It's utilizing what was intended when the Duke of Westminster, in the famous case dealing with the establishment of GAR in Commonwealth countries, common law rather, was established by saying every man has the right to order his affairs in a way so that he pays less tax, even if it's not appreciated by his fellow man or the tax authorities.
Thank you very much, Todd. Thank you, our presenters. Just to wrap up this topic on the foreign trust, I would like to mention one thing, is that we're not promoting using a foreign trust necessarily. Because we're talking about asset protection, we want to educate our viewers to show them ways they can achieve superior asset protection that's not available in Canada. If you don't like the idea of a foreign trust, you can always set up a trust in Ontario or in British Columbia or Alberta or wherever you happen to reside. We're just sharing some additional benefits of using a foreign trust, but the option is just an option. You can always go with a Canadian trust instead. We've also had some questions about how much assets do I need to justify having a family trust? In general, for assets of exceeding $2 million, we say maybe it makes sense to start looking at a foreign trust because you have to pay the foreign trustee to do his job. For amounts less than $2 million, it makes sense to look at a Canadian trust. And we've set up some of those for clients with quite a lot less than $2 million. So doing an estate freeze and a family trust is something you should be looking at as long as your business is growing. We're out of time for our presentation today. We did get through everything, and we're very grateful for the fact that everyone was able to attend today. I would just like to open up to our panelists. Do you have any questions that you'd like to answer that our guests have asked?
Yeah, so I would address the following question, and that is, does any property that was purchased previous to the relationship, can it be excluded from family assets when it comes to a separation? So net family property essentially refers to the property that accrues or grows in value from the date of marriage onward. There's no automatic entitlement for common law spouses, as they're called. It's people that are married have that. It's not that there can't be a claim for assets and distribution of property, but the entitlement under the Family Law Act applies from the time that two people are married to the time that, and the growth of those assets. What they bring to the marriage is excluded. There's one.
Well, I just want to say it's excluded subject to any increase in value that occurs during the marriage on an asset that is excluded because it was prior to marriage. That increase in value becomes net family property as well. So 50% is going to go to the spouse in any event.
Yep. Matrimonial homes, 50-50, yes. You can say whatever you want. You can create whatever agreements you want. Prenuptials or marriage contracts. 50% of the matrimonial home belongs to the spouse. So that's another question. Going down here, looks like we've had that question twice. We're talking about family farm assets transferred to only one spouse, and it's not always automatic that CRA will allow. Okay, I'm not understanding that question. I apologize. I'll continue. So there's a question about describing a bare trust, and essentially a bare trust is established for the purpose of making a distribution to a specific beneficiary, and essentially what we've been describing until now is a bit different. Keep in mind when you think of trust, there are different kinds of trusts. There's a testamentary trust that's created by your will. And then there's an inter vivos trust, which is in Latin, a trust for the living. So essentially, what we're really talking about is a trust that gives a lot of benefits during the time you're alive. You don't have to wait until you die to benefit from them. Can a trust own shares of a CPA firm is another one. Well, I believe that the CPA regulations do require that the ownership directly or indirectly is that of a CPA rather. So I believe that in general, we could relook up these rules again, because it's not really a tax issue. It's more of an association rule issue. Indirectly or directly, as the wording used to be, would imply that you could potentially use a holding company, providing that that individual would have the shares. You can channel money out of a professional corporation through a single wing butterfly, as an example, which is a way that we can take a large amount of money and move it to another corporation, which is called a sister company. It's called a sister company because it has the same parent. And then you could look at establishing a trust to protect those assets and achieve some tax efficiency. So the best answer is it depends, right? So there's a lot that can be done. In the first year of incorporating a business, my lawyers kept the minute book. Yes, your lawyer's keeping the minute book at his office. Absolutely. It's also important that if he doesn't automatically update them, that you get your accountant and your lawyer together and you get the minute books updated each year. And if they're not doing it, you have to be the one who nudges them, right? So that's the best thing to do. Can a trust hold real estate in Ontario for a beneficiary? It can. Sometimes along the lines of more a bare trust arrangement can be made for purposes of purchasing real estate, almost as a temporary measure. But a trust can hold real estate, of course. You can also do an estate freeze of property. So if you have a high value property or a property you can believe will become high value, consider a rollover, which is means that you take the property, you roll it into a corporation, take back the shares, you can freeze that value. There are land transfer taxes, but they're rather minor compared to the tax savings. I don't mean to steal all the questions, guys. Seems like I'm doing that.
Okay, I'll answer one. There's a question about providing your children and their spouse gifts or loans to buy a house. And in fact, you could have a loan agreement that specifically says it's not a gift and it's to be returned upon certain times. And you can get a lawyer to draw that up, or you can put a mortgage on the house in your name. And it can be an interest-free mortgage, but it's still a mortgage. And it's got to be payable by such and such a date. You can put in, you always can forgive that, but that's another way to protect your investment.
Yeah, and if you're buying a cottage, you may want to consider how you can do so in a tax-efficient way. Sometimes we set up not-for-profit corporations, and I did a presentation at the Ontario Bar Association that through COVID somewhere, I forget, about a year ago. And I think it's a pretty important thing to consider, because what you can do is you can purchase a cottage in a way that you're not going to be concerned with capital gains taxes at death. Since you don't have a principal residence exemption necessarily with a cottage, you have one, but you may have it, but you don't necessarily have that. Well, what we sometimes do is set up not-for-profit corporations that hold cottages. And essentially the members, as it were, it's like a club, tennis club, or some other kind of club, your own private club. You contribute funds in order to provide for the upkeep of the cottage. But the good news is when you die, well, there's not a huge tax bill the family has to worry about paying. So Jeremy, we go over time?
No, I think that's good. We're out of time. I'd just like to thank everyone again for attending. We really appreciate the great turnout that we've had today. The next webinar is scheduled for Wednesday, March the 9th, and we're going to be sending out the details by email. So hopefully we'll see you all back on March the 9th. Any closing remarks from our panelists?
Stay safe.
Thank all of the attendees for joining us.
Thank you.
Today.
Okay, thank you, everyone.
Uh,
Bye-bye.
Thank you.